Hi, everybody. Welcome to this second video on Chapter 3. Here we're going to continue talking about the legal system. So in this video, we're going to cover three things. First, we're going to talk about probable cause and rules of evidence. Then we are going to discuss the criminal justice system and compare that with the civil justice systems. Let's get started on probable cause. So underlying any arrest or warrant or search is probable cause. So probable cause is kind of the standard that law enforcement has to have in order to make an arrest or conduct a search or obtain a warrant. It's also the term that the grand jury uses when they believe that a crime has been committed. One of the first issues associated with probable cause is to determine what we're talking about. So this culpability scale. So these are kind of like the players in what we're talking about. So a witness is a person who is not suspected of a crime. And then as we move up in culpability, the target is believed to stand a better than 50% probability of being criminally charged with a crime. Somewhere in between a witness and a target is subjects. Subjects may have committed unethical conduct and may be involved in suspicious activity, but they haven't crossed the line to the point where their behavior is considered criminal. As evidence develops and the investigation proceeds, people can change from witnesses to subjects, from targets to subjects. They can move up and down between witness, subjects, and targets. So not surprisingly, most frauds and financial crimes are solved during using documentary evidence. So the documentary evidence is what we use. So this evidence is going to be key or the basis for most white-collar crimes. The challenge is specifically where probable cause comes into play is the issue of how to obtain those documents. So generally, investigators have three methods that they can use to obtain the documentary evidence that they need. So first, we can have voluntary consent. So voluntary consent gives the defense lawyer and their client time to gather and review relevant documents, negotiate limitations, copy what they need, and schedule when they're going to produce that won't disrupt their day-to-day business. So voluntary consent, voluntary turning things over without a subpoena or a search warrant. So a subpoena are issued by grand juries and used to compel witnesses to testify, and may also be used to compel people to turn documents over to the authorities. So grand juries have leeway when they're issuing subpoenas, and to meet the reasonable standards, the subpoena must be likely to generate evidence that's relevant to the issue under consideration, be particular and reasonably specific, and limited to reasonable timeframes. So one of the shortcomings of a subpoena approach to obtaining documents is that the investigator is relying on the recipient of the subpoena to determine what documents fall under the subpoena's particular details. So in a subpoena, you're asked to give something, and you get to determine what it is that you get to give them. So beyond subpoenas, so these are kind of listed in order of maybe severity, or I don't know. Search warrants may be used to obtain documents and physical evidence. So when we have a search warrant, these are issued by a judge based on the probable cause, and that puts the investigator in charge of the evidentiary search. So in a voluntary consent and a subpoena, it's the person giving the documents that decides what to turn over. In a search warrant, with a search warrant, it's the investigator who gets the search warrant that gets to go in and decide what is relevant and what to take. The threshold for probable cause is not very high. There must be some evidence, that's the probable cause, that a crime has been committed, and some belief that the search warrant will give us evidence to support that the person was involved in the crime. The limitation of a search warrant is that they need to be very detailed. It needs to include details such as where they're going to search, the people who are involved, the type of evidence that's likely to be seized. One disadvantage or problem that happens with search warrants is that if they're not documented well enough, then they could be challenged as lacking specific, that they're not specific enough. Advantages of warrants over subpoenas, again, allows the holder to decide what is relevant. So the subpoena lets the person who's giving the things decide, so they could hold stuff back. Avoids but does not eliminate the possible destruction of evidence. So you get the subpoena, you have time to destroy evidence before you turn it over. You get a search warrant, you don't have any of that time. They're coming in and they're going to get stuff. Interview key witnesses without opportunity to prepare. If you have a warrant, they don't have the opportunity to prepare. You can just interview them right there. If you have a subpoena, that gives them some time to prepare for those interviews. All right, the next thing we are going to talk about is rules of evidence. So without evidence, there's no proof. Without proof, there's no convictions. So there's an old saying that the truth will set you free, but that truth needs to be grounded in evidence. So evidence is anything legally presented at a trial to prove a contention or to convince a jury. Generally, evidence is admissible in court if it's relevant, has probative value, and outweighs any prejudicial effects, prejudicial effects. Has to be trustworthy, meaning that it is subject to examination and cross-examination, and the definition and types of evidence will be explored further in the chapter. In this, we're going to talk about that coming up. For the purpose of exploring the rules of evidence, evidence may be testimonial, real, demonstrative, circumstantial, such as fleeing the scene of a crime, or direct, the testimony of an eyewitness. So real evidence is the evidence that speaks for itself and does not require any testimony. So a baseball bat that has a victim's blood and hair and DNA on it speaks for itself. That's considered real evidence. To be admissible, real evidence must be authenticated. The evidence has to be properly collected, has to follow the chain of command to make sure that it's preserved, and it has to be identifiable as it moves through the judicial system. Demonstrative evidence is the evidence that educates, summarizes, or amplifies real evidence. So this can be like PowerPoint slides or summaries or graphics, anything that can demonstrate evidence. Demonstrative evidence tends to tell a story and complement other forms of evidence, such as real or testimonial. Documentary evidence is at the heart of most fraud and forensic cases. So 5 considerations must be given to any piece of documentary evidence. So first, it can't be forged. So we have to be able to identify that it is not a forgery. Original documents are best, but sometimes they're not available, so copies are allowed. The documents must not be hearsay or objectionable. The documents need to be authenticated and they have to be reliable. So while an original document is preferred, the best evidence rule allows for copies to be presented at a trial under certain circumstances. The chain of custody refers to those individuals who have possession of physical evidence and what they did with it. So essentially, fraud professionals and forensic accountants must be able to establish the origins of evidence and that the evidence has not been altered during the investigation. The chain of custody protects against the possible corruption of evidence as the result of the investigators losing control in it. So close monitoring of all physical evidence is important in a fraud investigation. Testimonial evidence brings about a discussion of hearsay. So what happens if one person hears another person make a statement, or one person makes a statement that so-and-so said something? These are not allowed. So documents cannot have hearsay. So each person must testify based on his or her own experiences. So in the last video, I talked about the criminal justice funnel, and that most cases never actually end up in the criminal justice system. However, those that do end up in the criminal justice system typically will follow a pretty generic path. So we start either a warrantless arrest by police for probable cause, or some investigation that leads to the filing of information, or a grand jury proceeding that leads to an indictment and a subsequent arrest warrant issued by a judge. So those are kind of the three ways that we can enter the criminal justice system. So assuming an arrest, the law enforcement personnel provide the investigative outcomes and evidence to the prosecuting attorney, who decides whether charges will be filed against the target. Once the charges have been filed, the person will appear in front of the judge, and the judge will decide if probable cause exists to move forward. And for less serious crimes, the judge may decide a verdict and a penalty at that time. Without necessary delay, we can't hold people for a long time before we allow them to appear before a judge. So they have to be put before a judge rather quickly. Assuming that the criminal case proceeds beyond the indictment stage, where the defendant is officially charged, the next step is an arraignment hearing. During the arraignment, the defendant is informed of the crime and the charges against him, and advised of his rights, and asked to enter a plea of guilty or not guilty, or nolo contendere, which is a plea where the defendant accepts the penalty without admitting guilt. So I'm going to accept the guilty plea, but I'm not admitting that I'm guilty. If the judge accepts the guilty plea, a penalty will be issued and no trial will be scheduled. Assuming a not guilty plea is entered, or guilty by reason of insanity, then the judge will schedule a trial. The defendant may choose either a bench trial or a trial by jury. A bench trial is where only the judge presides. In a trial by jury, the judge still decides matters of the law, like objection, but the jury actually decides whether the evidence is presented in sufficient, whether the evidence is there to convict the defendant. If the jury acquits the defendant, then the person gets to go free. If the person is found guilty, then a sentencing hearing is scheduled. The sentence may be determined either by the judge or the jury, depending on the jurisdiction. And during the sentencing hearing, we may see some mitigating circumstances may be presented. That's like factors that lessen the severity of an act, or the person's culpability for the action. And then after sentencing, they could be put into the prison system. So jail is for sentences of less than a year, and then prison has varying levels of custody. So a community-based is going to be far less than maximum security. After they're convicted, someone can appeal the verdict. They were found guilty and they still contend that they're not guilty. The sentence may have been too harsh, or they could appeal both. So parole versus probation. So parole is after prison. So you get out for good behavior, that's parole. Probation is, the crime wasn't severe enough to send you to jail or prison. Instead, we're going to put you on probation. So parole is after prison, probation is instead of prison. this R word. I'm not even going to attempt it, but what that means is we have repeat offenders. So when someone who has been in the prison system before comes back into the prison system, it's very common for repeat offenders to have multiple offenses. And then lastly, remember that the justice system is not just for people, but businesses and organizations can be prosecuted through the criminal justice system as well. All right, now let's talk about the civil justice system. So where the criminal justice system is the state prosecuting a wrongdoer, the civil system is a means for people who have been wronged to sue the wrongdoer. So what are they suing them for? Either to right the wrong, resolve a dispute, get money or settlement, recover losses, punitive damage, or like a cease and desist order. So they want someone to stop doing something. So those are kind of the reasons that you may go into a civil justice system. So how does this kind of work out? So a civil lawsuit begins when the plaintiff files a complaint to whatever their jurisdiction, and the complaint must provide assurance to the court that it has jurisdiction, outline the grounds for relief, and make a demand for judgment. In a fraud case, the complainant must include 3 specific things. So they have to include the fraud misrepresentation, the impact on the victim, and how the misrepresentations were false. So that's what has to be included for fraud civil complaints. Discovery is how you get information that is relevant to your case that the other side has. So how do we do this? So first, we have interrogatories, which are questions that require answers, and those answers become part of the testimonial record. So we just send a list of questions over to the other side, and they answer those questions and send them back. So while these are one of the least expensive means to obtain evidence from the opposing party, there's the inability to ask follow-up questions except through additional lists of questions, and therefore they might be pretty ineffective. So opposing parties tend to provide truthful responses, yet minimal information. So you might need a little deeper dive. So that is where we have the request to provide documents. So after we've asked our questions, the opposing parties are going to submit the request to produce documents to one another. So just about any information that is captured on paper or electronic form is subject to discovery and can be requested as documents. Third, the attorneys start to take sworn testimony from opposing parties in the form of depositions. And then finally, the fourth and final stage of discovery is an attempt by counsel to get the other side to agree to certain basic aspects and facts of the case through requests for admission. So this process helps to determine the issues that are points of contention before the trial starts. So here we try to find points that we can agree upon, and then that helps us narrow the scope of the trial to only those essential points of contention that we can't agree upon. Once discovery is complete and before a trial, the judge will often attempt to coax the sides into settling their cases. The textbook states that it's estimated only 5% of civil cases actually make it to court. So what do the other 95% do? They do one of these 3 things. So the first is out-of-court settlements. So out-of-court settlements occur when both sides can come to a settlement position after examining the important aspects of their case. So I look at what I have, you look at your side, and we're able to work together like adults and come up to a conclusion. So the attorneys will meet with their clients, meet with each other, and they're able to come up to some conclusion. So if that doesn't work, the next approach is mediation. So in this environment, an independent, objective mediator will work with both sides of opposing counsel to help them reach a settlement between the two and their clients. The mediator does not decide who wins, but is simply there to assist both sides to be more objective and assess the merits of their case and work together to a mutually agreeable resolution. The third possible situation is arbitration. So like a mediator, an arbitrator is an independent third party who has the authority to determine the outcome. So a mediator does not have that authority. The arbitrator has the authority to determine the outcome. So the arbitrator acts like the judge and jury, listening to both sides, the primary aspects of their cases, and decides what he or she believes to be the most appropriate outcome based on the merits of the cases presented. Arbitrations can be binding, meaning that the verdict of the arbitrator is final, or it can be non-binding. So in a non-binding verdict, that might bring the parties closer together and may result in an out-of-court settlement because of the ability of the arbitrator to be independent and objectively evaluate the merits of each of the cases. And then the last thing that I want to talk about today is pre-trial motions and the civil trial. So assuming that the discovery process is complete and any out-of-court attempts to settle the case fail, then a whole bunch of pre-trial motions are likely to follow. Normally, a counsel is going to object to any motion proposed by the other side of the civil action, and the judge will have to decide which motions to advance to the trial. While many aspects of the civil trial mirror that of the criminal trial, there are a few important differences that exist. So first, there's smaller juries, in most cases just 6. And if the opposing attorneys agree, a unanimous verdict is not required. So as long as there's a majority, 4 out of the 6, then that's who would win the trial. Also, a civil action only requires a preponderance of the evidence, meaning that the evidence stacks up slightly more heavily on one side than on the other. This is in contrast with the criminal threshold of beyond a reasonable doubt. And also, once a verdict is received, either side may appeal the liability issue or the damage portion of that verdict. Whoever wins money in a lawsuit will normally have to take additional steps to collect the award, such as obtaining a financial judgment or garnishing wages or levying assets. And a post-judgment discovery process may be necessary to locate assets available to satisfy a judgment, or identify assets that have been moved or transferred in an attempt to avoid satisfying the judgment. So that is it for today. I hope you enjoyed chapter 3, and I'll see you next week for chapter 4.